Jefferson County Code at Law number 2 is back in session. Court is back in session with your arraignment docket. First case is cause number 23CCCR 0404. Case is styled the state of Texas versus David Rogers. Mr. Rogers, would you please come forward? For the record, is your name David Allen Rogers?
Yes, sir.
Mr. Rogers, would you please raise your right hand? Mr. Rogers, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Rogers, you may put your hand down. How are you doing, Mr. Rogers?
I'm doing all right, Your Honor.
That's good.
Thank you for asking.
You're welcome. Now, Mr. Rogers, I have before me a couple of documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir, Your Honor.
And are these, let's see, this is your initials on the line saying you want to waive your right to an attorney and to represent yourself?
Yes, sir, Your Honor.
Okay. I also have another document here that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, sir, Your Honor.
Now, Mr. Rogers, before you signed the initial of these documents, did you read the document?
Yes, sir, Your Honor.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, Your Honor.
Okay, Mr. Rogers, just have a seat and someone from the district attorney's office is going to talk to you in a few minutes.
Thank you very much.
You're welcome. Next case is cause number 23CCCR 0708. Case is filed the state of Texas versus Kendall Cortez Anderson. Mr. Anderson, is your full name Kendall Cortez Anderson?
Yes, sir.
Mr. Anderson, would you please raise your right hand? Mr. Anderson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down, Mr. Anderson. How you doing, Mr. Anderson?
Good.
That's good. Mr. Anderson, I have before me two documents. The first document is titled Judge's Explanation of Right to Defendants Without an Attorney. Well, actually, I have one document. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the document that states I want to reset my case to hire an
Yes, sir.
attorney? I also have, now, Mr. Anderson, before you signed and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in this document true and correct
Yes, sir.
to the best of your knowledge? Now, Mr. Anderson, I also have before, I need to give you some bond conditions. Mr. Anderson, just been handed a document that is titled Standard Bond Conditions in County Code at Law number 2. Do you see that title?
Yes, sir.
I'm going to go over this document with you, and it reads as following. Following the return of a criminal information in County Code at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you see that condition? Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply in this case, and condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. You understand that condition?
Yes, sir.
Now, Mr. Anderson, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest and you'll be placed in the Jefferson County Jail. Do you understand that?
Yes.
Now, Mr. Anderson, our court coordinator is going to reset your case. Once your case is reset, you'll be free to go and you have a blessed day. Please stand and have a seat at that first chair at the wall. Next two cases are cause numbers 23CCCR 0648 and cause number 23CCCR 0649. Both cases are styled the state of Texas versus Jordan Artie McCracken. Mr. McCracken, your full name is Jordan Artie McCracken. Mr. McCracken, would you please raise your right hand? Mr. McCracken, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. McCracken, you may put your hand down. How are you doing, Mr. McCracken?
Pretty good.
That's good. Mr. McCracken, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
I do.
And is this your signature on the line that's titled defendant?
It is.
Are these your initials on the line that states you would like to have this case reset to hire your own attorney?
Yes.
Now, Mr. McCracken, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Now, Mr. McCracken, I also have some bond conditions for you. And Mr. McCracken, the document that just has been handed to you is titled Standard Bond Conditions in County Code at Law Number 2. Do you see that title?
I do.
I will go over this document with you, and it reads as follows: following your return of your criminal information in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
I do.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body, and is pursuant to the Texas Code of Criminal Procedures, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes.
Now, condition number 3 does not apply. However, condition number 4 does apply. And condition number 4, because you are charged with a DWI second is a subsequent offense listed under Section 49.04 through 4906 of the Texas Penal Code, and condition number 4 reads as follows: a defendant whose information charges any subsequent offense listed under Section 49.04 through 4906 of the Texas Penal Code shall not operate any vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after today. Do you understand that condition?
Yes.
Now, condition number 5 also applies. Defendant is prohibited from possessing firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for arrest, and you'll be placed in the Jefferson County Jail. Now, Mr. McCracken, our court coordinator is going to reset your case. Once she resets your case, you'll be free to go. Now, you can provide proof to the court within 10 days that you have the interlock by either faxing that information or emailing that information to our court, and our court clerk can give you the email and the fax number so you can send it to the court. Or if you want to come up to the courthouse, you can bring it to the court, and if the court is not in session, you will go through the blue doors that's next to this courtroom, walk up to the glass window. They should have a receptionist there. If the receptionist, you can give it to the receptionist, she'll give it to us. If the receptionist is not there, there's a number on the wall by the phone that you can call to the county court at law number 2, and we'll have someone come out and get it. Okay, just please have a seat in the first chair by the wall. And once you get your reset, you'll be free to go, and you have a blessed day. Thank you. Next case is cause number, or 2 cases rather. Cause numbers M330860 and cause number M330914. Both cases are styled the state of Texas versus Desiree Nicole Lambert. Ms. Lambert, you can come forward. Ms. Limbrick, is your full name Desiree Nicole Limbrick?
Yes, sir.
Okay, Ms. Limbrick, would you please raise your right hand? Ms. Limbrick, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Limbrick, you may put your hand down. How are you doing, Ms. Limbrick?
Oh, fine. How you doing, Derek?
I'm doing fine. Thanks for asking. Ms. Limbrick, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Sir.
And is this your signature on the line
Yes, sir.
that's titled defendant? Or these your initials on the line that states you would like to apply for a court-appointed attorney?
It is.
Also, I have another document here that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Ms. Limbrick, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Limbrick, I read your answers. Based on your answers, you meet the eligibility requirements of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Brevin Jackson. Attorney Jackson will be given information on how to contact you. You also be given information on how to contact him. Once you get that information from our court coordinator, you'll be free to leave, and you have a blessed day. Please have a seat in the first chair by the wall.
Thank you.
You're welcome. Same to you. Thank you. Next case is cause number 23CCCR 0370. Case of style of state of Texas versus Jared Ronaldo Matthews. Mr. Matthews, is your full name Jared Ronaldo Matthews? Mr. Matthews, would you please raise your right hand? Mr. Matthews, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Matthews, you may put your hand down. Mr. Matthews, how are you doing? You doing all right?
Yes, sir.
Now, Mr. Matthews, I have before me a document. I have two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature online that's titled Defendant? Or these your initials on the line that states you like to apply for a court-appointed attorney? I also have before me a document that is titled Jefferson County Affidavit of Indians. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Matthews, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Matthews, based on your answers in these documents, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that is appointed to represent you is Attorney Benjamin Jeffries. Attorney Benjamin Jeffries. Attorney Jeffries will be given information on how to contact you. You also be given information about how to contact Mr. Jeffries. Our court coordinator is going to give you that information. Once you get the information from our court coordinator, you'll be free to go and you have a blessed day. Please have a seat in the third chair on the wall. Next case is cause number 23CCCR 0446. Case is style of state of Texas versus Kyle Anthony Jackson. Mr. Jackson, would you please come forward? Mr. Jackson, your full name is Kyle Anthony Jackson? Just speak up. Okay, Mr. Jackson, would you please raise your right hand? Mr. Jackson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Jackson, you may put your hand down. How are you doing, Mr. Jackson?
Good.
Doing good? Mr. Jackson, I have before me two documents. The first document is titled Judge's Explanation of Rights for Defendants Without Attorney. You recognize this document? You have to speak up.
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes,
There's a set of initials on the line that state you'd like to apply for a court-appointed attorney. Did you place your initials on this document?
yes, sir.
I also have another document here that's titled Jefferson County Affidavit of Indians. Do you recognize this document? On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Mr. Jackson, before you signed and initialed these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Jackson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that is appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be contacted and given the information on how to contact you, and you also be given information on how to contact Mr. Lawrence. Just have a seat in that third chair by the wall. Our court coordinator is going to call your name. Once she calls your name, go up to the window. And once you finish following her directions, you'll be free to go. And you have a blessed day.
Roger, David Roger.
Okay.
I did, when I spoke with Mr. Rogers, he requested, pro se and to speak with us about an offer, in our conversations, talking with them. Either one of the offers that I given Mr. Rogers, he's in a unique situation because he doesn't live in Texas anymore. He lives in Mississippi. So probation would be maybe complicated in that he lives there and he works all over the country, and he's moving to Kansas City soon. So probation is a problem. Therefore, I gave a offer of a jail time, but he doesn't have the ability to do that time when he needs to be done. So we're kind of at an impasse. As from the state point of view, I don't want to sign him up for something that it's an impossibility for him to complete. So we're kind of what if suggested from the court, but we can.
Oh, I can't
I understand.
suggest no punishment. I mean, we're not at the punishment phase at this
for
point.
sure.
Yeah.
So, but what I'm not going to offer anything that the defendant can't complete, and either one that I can offer or the state is willing to offer is or can't be done. So
now you have two options. We have three options regarding your right to have an attorney. You can ask that the case be reset to give you time to hire an attorney. Or two, you can see if you qualify for a court-appointed attorney. And three, the third option, which you had previously chose, you have a right to waive your right to have an attorney represent yourself. And I think in a document that's titled Standard Bond Conditions and County Court Law Number, that's titled Judge's Explanation of Rights to Defendants Without an Attorney, the last paragraph states that if you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Okay? So at this time, we can, if you want to change your mind, you can, and you will indicate your change on the document that is titled Judge's Explanation of Rights to Defendants Without Attorney. If not, then we'll proceed from there.
Yes, sir. I'd like to continue with my
So you want to continue. So at this point, hold on. Let me do this here. I got to give him a Ferretta. Go on in.
you need this judge, you want this?
No, he could hold on to that. Now, at this point, pursuant to the case of Ferretta versus California, 422 US 806, the court is going to ask you the following questions. Okay. Number one, have you ever studied law?
No, sir. Yeah.
Okay. Have you ever represented yourself in a criminal case?
Yes, sir. Yeah.
You have. Do you understand the charges against you?
Yes, sir.
Are you aware of the maximum penalty for the charge?
Yes, sir, Your Honor.
You are? What is the maximum penalty?
I think it's 180 days
Up to a year in jail.
or 365 days.
Yeah, this is a DWI second. Yeah, so the range of punishment is minimum 30 days to a maximum of 365 days in the county jail. You understand that?
Yes, sir, Your Honor.
And you could be given a fine that does not exceed $4,000. You understand that?
Yes, sir, Your Honor.
Okay. Now, are you familiar with the exact legal elements for each for the charge?
No, sir, Your Honor.
Okay. Now, do you realize that if you are found guilty of this offense, you could be punished anywhere within the punishment range? Your punishment can be anywhere within that range. And that you may qualify for probation as well. Do you understand that?
Yes, sir, Your Honor.
All right. Now, do you realize that when you represent yourself, you are alone? In essence, you are your attorney.
Yes, sir, Your Honor.
And you realize that as a judge, I cannot tell you how you should try your case or even advise you as how you try your case. You understand that?
Yes, sir, Your Honor.
So I cannot help you in any way. Understand that? Are you familiar with the Texas Rules of Evidence and Texas case law?
No, sir, Your Honor.
Do you realize that the Texas Rules of Evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules. Okay, so in the Texas Rules of Evidence, for example, if you are trying to get evidence into your case, for example, you might be trying to offer some type of evidence into the case. There are certain rules that govern how evidence comes into the case. Do you understand that?
Yes, sir, Your Honor.
And so you're going to be held to that standard. Just because you are not a lawyer does not prevent you from being held to that same standard. Do you understand that? You'll be held to the same standard as a lawyer.
Yes, sir, Your Honor.
Okay. So there won't be any shortcuts. All right. Now, and for example, do you know how to conduct a voir dire?
No, sir.
Do you know what a voir dire is?
No, sir, Your Honor.
Okay, it's when people are trying to pick a jury in a case. And now you said that you represent yourself in the past in a criminal action. Is that correct?
Yes, sir, Your Honor.
Did you-
say that? That's I just pled guilty.
Okay, so you didn't pick a jury or anything of that nature.
Yes,
Okay.
sir.
Now, do you know what grounds there are for excusing a juror for cause?
Yes, sir, Your Honor.
Do you know what is hearsay
Yes, sir, Your Honor.
and what is hearsay?
It says a room.
Could be one example of, could be, okay,
Hearsay.
okay. Do you know how to impeach a witness? Do you know what the, okay, you
No, sir.
don't. Do you know when is character evidence allowed into evidence?
No, sir.
Do you know when and how to make proper objections?
No, sir. Your Honor.
Do you know when and how to move for a directed verdict?
No, sir. Your Honor.
Do you know how to proffer or offer evidence to protect the record for appeal?
No, sir. Your Honor.
Do you know the proper grounds for mistrial?
No, sir. Your Honor.
Or you're aware that the failure to timely move for mistrial may waive crucial mistakes made by the state or this court. You don't understand that? Do you know how to request and object to jury instructions?
No, sir.
Okay. Are you familiar with the Texas Rules of Criminal Procedure?
No, sir.
Do you realize that those rules govern the way in which a criminal action is tried in court?
No, sir.
It was law.
Now, Mr. Rogers, I must advise you that, in my opinion, you would be far better defended by a trained attorney than you can be by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with the law. You are not familiar with court procedures. You're not familiar with the rules of evidence. I would strongly urge you not to try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by an attorney?
Yes, sir.
That's still your desire,
Yes, sir.
okay? And is your decision entirely voluntarily on your part?
Yes, sir.
Well, I find that the defendant has knowingly and voluntarily waived his right to counsel, and I will therefore permit him to represent himself. And so at this time, Mr. Rogers, what we are going to do, we're going to have to reset this case. And the reason why is because at this point, you don't have an offer from the state. And when we talk about an offer from the state, you should bear in mind that the state is not obligated or required to give you an offer on the case, okay? And so we don't have an offer. And as I mentioned earlier, doing arraignment, I mentioned that a person has two options. Well, they have some options if they did not have a trial by jury. One option is they can have enter into an agreed plea bargain agreement. You don't have an agreed plea bargain agreement at this point. The other options, you could do an unagreed plea bargain agreement. That is, you enter a plea of guilty or no contest before the judge, and the judge assesses punishment. Now, at that point, you don't know what the judge is going to do, right? And whatever the judge does in your case is unagreed, and so therefore, that's the decision. So you don't know ahead of time what you're going to get.
Just.
Okay. And let's see. And the other option was a bench trial. A bench trial is where you try your case before the judge without a jury. And then the judge will listen to the evidence and decide whether or not you're guilty or innocent. And at that point, if the judge finds you're not guilty, the case is over. The judge finds you guilty, then the judge will also assess the punishment. Do you understand that?
No, sir. I apologize. I just blinked out for a second.
Okay. I mean, there's a lot of stuff.
Yeah.
That's why I mentioned to you what I thought about you representing yourself.
Yes, sir. Your Honor. I came here today just to plead no contest and put this matter behind me. I wasn't aware of the legal technicality.
Right. That's why we have arraignment
Okay.
to let you so you could become aware
Yes, sir.
of the consequences of entering a plea of guilty and no contest. That's why we tell you that there are dangers and disadvantages to self-representation. Okay.
Yes.
Okay.
Now, Judge, before, if you don't mind, I apologize, but before we give a date, if I could have a second to speak with Mr. Rogers,
Okay.
because there may be a way. Now, I got to talk to him to see if that otherwise, then it just has to be a date.
Okay,
If it
I'm saying,
can be a special date, where the state's willing to work with him on, to work it out, where if he knows of a time. Then we can set it at a time.
okay.
That, maybe not do anything today, but in the future, if he's willing to work with his employment and all that, we can resolve it. But I gotta talk to him just.
Okay, so we'll
Before we
be,
give him a date.
okay, we'll be in recess.
Like-
Just